Why don't you go see your boyfriend?
Yeah, he's got a nice room. You won't have it long. He left a call for 7 a.m.
See if we can figure out something.
Listen to a problem.
Hiya. I think, Lilith, it's just you and I. I've got a virtual background on because I'm sitting on the bed. My studio/office is currently a bit more of like a video editing layout. So we're rolling with a virtual background in the bed. And I haven't found like anything specific that I want to watch. So I think we're probably just going to do a little bit of like general court hopping. A member and a mod. Wow. YouTube keeps asking me if I want to renew my membership to my channel. And I'm like, I mean, I could, I guess. Hey, Sim. Hey, Donald. I'm sure there'll be quite a few court vibes people jumping in because I said that I would go live today because Kathy is working on Wednesdays. So it's a nice way for me to dip my toe back in slowly and then like do an hour here and there and take it from there. This virtual background is not great, is it? I mean, thankfully it's not messy behind me. I just haven't made my bed properly. Like, you know, when you just pull the blankets up to the duvet and you don't like make it neat. Do you want to keep paying for your own channel? Exactly. I do get like a percentage of the membership fees. I don't remember the exact breakdown, but yeah, it's say like if I was paying 35, I think I would get like 20 and YouTube gets 15. You need a green screen for it not to look bad. It did say that. And I was like, that's if I had a green screen, I probably wouldn't be using a virtual background. Okay, let's watch some Judge Webster because she never leaves things up. And she left yesterday's up.
5-4. Your Honor, I'm waiting for instructions.
Tuesday, April 1st, 2025. And somebody's going to need to mute. You're making way too much interference.
Whoever's left, Renee, please mute. I muted you once. Please don't unmute this time.
Thank you. This is the 13th Judicial. We are now on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. This matter comes on for our April 1st, 2025 first appearance docket. If you'd like to proceed, Mr. Carlos. And for
I'm
some reason,
multitasking.
I'm not hearing your voice, but I'm not seeing that you're muted either.
Bien, estamos ahora en la grabación en el listado.
And 6 months possible jail sentence.
Yo creo un abogado.
Su audiencia al
Nothing further will be in recess and been remanded to the sheriff.
Ok, si no hay nada más que agregar, entonces se levanta.
Case number. Thought it would be quicker doing this with paper, and I think it's quicker online in this instance. So give me just a moment. We are on the record in 2023 CR20, State of Kansas.
I think we're going to bump it up to 1.25. Also, if you have YouTube Premium, you can now go up to 3. I love it.
Versus Brandon Ray Jackson, County Attorney Jill Gillette appearing for the state. Mr. Jackson appearing in person and pro se after an absence of time. Mr. Jackson, you are here because a bench warrant to show cause was issued alleging that you had violated your probation on charges of possession of marijuana and drug paraphernalia. You were put on probation September 8th of 2023. Your probation officer alleges that you have violated by failing to pay costs and fees, by violating the law, and by not completing treatment. This is sworn to by Court Service Officer Anthony Bauer. We've had a warrant out for you, it looks like since July 12th of 2024. Your bond was set at $2,500 cash or professional surety at the time.
Wait a minute. I just decided. Let me just make myself bigger. Yesterday, I was watching Judge McBurney. He was the Airbnb trial. And he had a soft sit. And honestly, the man is such a master with these situations. Just give me one sec. I was going to make it a standalone video, but we might as well watch it together and then see. So here, there's a little bit of hot mic talking about pro ses. Should be able to have captions on by now. Yay! Thank you so much. Honeymoon fund, because we're honeymooning on the 18th and we haven't booked anything yet. Not even flights. We know we're going to Europe. We haven't figured out anything else. Thank you so much, Donald.
That's it. So Pierce, whatever you want to do with Dandridge and Taylor, and we'll see what's happening with Mr. Estrella. Okay, good.
FYI, there's the encrypt hard drive that's back on this screen.
Yes, and I think there's a way you can drag it down. They have to, they know that, and they were supposed to make it go away temporarily, and then they have to come in here and reboot all the machines.
It did go away for a little while, but
It's back. Okay, we'll let them know. Thank you. All right, so I'll come back out in a moment and we'll handle Mr. Pierce. So the jury's deliberating in range? All right.
We know we're flying in and out of Paris. We know we're probably going to do Disneyland. We want to go to Eggersheim. Eggersheim. I don't know how to say it properly. But that's where... Oh, listen to this.
Hey, how come you're still, do you have more cases? Oh, you have half of Dandridge if it was going forward.
well, I have Taylor.
Oh,
Both of
okay.
them are registered.
Right, okay.
Although,
Taylor's, I'm full pleading.
I
so
might be
just
too
stick
far
around for
back.
that, please.
Maybe I'll have it. Still there about maybe. Oh, you want to just work out. Oh, I'm so sorry. I'm so sorry. I'm not making that any better. I heard they put cavities that I won't eat candy anymore.
I'm just prone to cavities. They gave me some special toothpaste. Excuse me. I don't think that won't work. What? I'm talking to him.
You know, try them. So you don't have what happens there. Yeah, but try them on. We can go.
I look just like it. I think targets and I have to take lots of evening.
Yeah, I know.
I gotta walk my dog today.
Yeah, I don't take mine home. Can I get home?
That's target. I don't have any allergies, so the pollen doesn't bother me.
It doesn't bother me, but
Ugh.
I heard it.
Oh. You know, she was freezing.
They were talking about subsets.
And I was like, I can eat this first. I was like, oh. So my mom was like, did he cry when he was like, yes.
Ugh.
It's just called for pet spray. It was gonna stay, but I think I'm about to leave. Traffic. Yeah.
There's others, so if I leave out by 4, it's not bad. Like 80.
Yeah, it's supposed to be in like close to 80s. So
Yeah.
the week.
But who? Mr. Pierce?
Yeah, wait.
I think he's doing his plea in arraignment, maybe, because now that he's representing himself.
Yeah.
Does I don't know if judge makes someone sit when some women are sovereign citizen. Like I don't know if I'm still gonna have to sit and just not do anything at the trial. Some judges make you do that, just sit. I don't know. I was like, how long is this going to be allowed? He was talking about the Pope, and then he said something about 1862. I was like, what is he talking about?
My favorite was the when it's he said something about once it's been determined that I have been found determined not guilty. Of course. Yeah.
Oh, they owe him all this. Like, I just like that. It's always like you be trolling.
At that point, I had to roll away because I was like, "Oh, okay."
That he has at one point that when at one point, no, when we were born, we didn't sign a contract to be United States citizens. We were just born. That was actually true.
Oh, that's a pretty happy number.
Acting like he's writing it down. Like for what? This would be a ridiculous trial.
Yeah, I used to go to work at Clay County. We used to get because they were coming out $100,000. Why you shouldn't pay for it?
But then my thing is like, have you seen someone else do it and it worked? So why are you doing it?
Okay, so in our office, we used to show up, running show. Share with me somebody somewhere you give like classes. And we figured because they would come like
They must be able to figure it.
every time they would come back, we figured somebody graduated.
But it's like, are we telling them a success rate though? Because I would, if I was doing, I would want to know.
And somebody is not giving the whole truth, because then about 4 months later, after they found like $1,000, and they're on our list of your house is getting ready to be auctioned. And yes, I have had some. Now, they usually come in trying to start throwing a mess. They come in angry, I don't know why. And so after I used to develop a report for them, and I was like, okay, what we gonna do today? And they would come in with like $50,000, and I'm like, all right. And then they would come in after the last, yeah, Karen's gonna take your house. And they come in like, oh no, I ain't still waiting. All my stuff. Or I remember one guy came in and filed his own documents.
Because that's crazy. Like,
Ms. Rivers, you know, I have to leave. She can sit still. She watched me move by one leg look to the left or the right.
I
All right.
I thought that was really funny. Before I go, let me just catch up on this. Oh, wow, lots of messages. We know we're going in and out of Paris because it's the cheapest to fly to and from. Disneyland is probably a must. I've been twice, but you can never go enough times. And we want to go to like, I think mostly like Parisian countryside sort of thing. Like we want to be out of the city a bit. High security. Also, hi, Kelly. What's with all the sailor talk? Oh, I'm so glad because when I gifted the memberships, we didn't actually see who they went to. YouTube must have glitched because it was literally just like, it said, because I get 10 free a month. So it was 5 were gifted. Nothing happened. I was trying to hit sim and then I did 1 and nothing happened. So I'm so glad they actually came up. Hey, Twitchy. Is this the jurisdiction? Yes. He doesn't say jurisdiction. He says jurisdiction. He's actually quite difficult for me to understand. I don't struggle a lot with US accents in general, but his I did struggle quite a bit. Okay, let me go. Evie, oh my gosh, hi. I've messaged you 75,000 times in my head. It's not a new setup. It is basically, I am sitting on the bed because the office is not a usable space at this point, and I didn't make my bed very nicely, so I'm using a background.
Ms. Rivers is back, so I'm back. Are we ready for Mr. Pierce?
Are we?
So I have this, which was from you. Is there anything additional?
There's the digital media, but I don't think you can take that.
No.
That's it. That's all the paper.
Okay. Can we bring Mr. Pierce out, please?
I have no words. The one that he designed in bed while he was basically dying. I would love to go, but I'm going to be honest with you guys. Right now, the US scares the out of me. I don't want to leave my third world country to travel to.
Hey, Mr. Pierce, come to the podium, please. Give me 1 second. Finding out about your scheduling order. Okay, let's get on the record, please. Ms. Rivers, this is 24SC003257, State versus Ricky Pierce. Mr. Pierce is in court. He was at an earlier proceeding. He and I had a long conversation about self-representation. I've entered an order allowing him to represent himself or honoring his request to represent himself. Today, we're going to cover 3 things, Mr. Pierce. 1, we need to do your arraignment because we weren't sure if you were going to have a lawyer or be your own representative. I held off on arraignment, so we got to do arraignment. 2, I'm going to, on the record, get you the paper part of your discovery, which you can take with you. And then 3, we're going to talk about scheduling so that your case catches up with Mr. Baker's. So let's start with the arraignment.
Before we can get into the it's a lot of issues that I had that I want to address before we get started with the arraignment. it's a lot of, it's just a lot of questions that I have that I need to be answered.
Okay. So why don't you give me an example of one of the questions, and then I'm actually going to decide whether we do arraignment first or your questions first.
Well, the law state that in Hagan versus Levine state that anytime a jurisdiction is challenged, that it must be proven before the case proceeds.
Okay.
And you're trying to proceed with this case without establishing jurisdiction first. That's the law, Your Honor.
Okay. It will work better as you and I are working together on this. If you've got legal concerns, you put them into a motion. So
I
if
have
you,
filed a motion already, but Your Honor,
so I'm gonna look and see what's in the docket.
it states that a court cannot proceed without establishing jurisdiction first, Your Honor. This
Okay.
is the law. I'm not saying nothing that's against the laws of Georgia, Your Honor, or United States.
She can't take down, we talked about that. She's trying to take down everything you said.
Right. So pause. Just hold on, Mr. Pierce. I'm looking in the docket here, and I'm not seeing that you filed, and it just may not have made it yet, that you filed a motion challenging jurisdiction. But I'm happy to let you know right now, I'm real comfortable with the court's jurisdiction. That doesn't mean I won't.
Your Honor, it states that the proof of jurisdiction beyond reasonable doubt is asserted. I'm the one asserting jurisdiction here, Your Honor. So that means I have to prove jurisdiction, but you got to give me the opportunity. If you don't give me the opportunity, you're violating my rights, Your Honor.
What's in your mouth?
Paper.
Oh, okay. I just want to make sure everything.
But yeah, the law states that the asserter establishes jurisdiction is to prove jurisdiction, Your Honor. You're not letting me do that.
Okay.
You're not.
Okay. Well, I got you. So one, we got to speak slowly, and two, now I'm better understanding. You're saying you want to prove jurisdiction?
Yeah, I'm the asserter. Can I just read my question? Just go through it's not that long.
Okay. You said a whole bunch, but if it's not that long, how about I listen to you?
Your Honor, there's a lot of things I'm not understanding right now, and it's a lot of questions I need you to answer. So I can better understand what is going on up until this point, Your Honor. Like, hey, I changed the court jurisdiction on March the 4th, 2025, and also filed a motion that's right here that's I have signed by the clerk saying that it's been filed. But this is the motion right here that I have filed. I have here something copied back and everything. And plus, the courts are still trying to proceed with my case when you guys lack subject matter jurisdiction. Plus, it states in Louisville versus Motley, if any tribunal find absent proof of jurisdiction over a person or subject matter, the case must be dismissed.
Okay, slow down. I'm gonna let you keep reading. Just slow down so Ms. Rivers can get what you're saying.
And also, Your Honor, once jurisdiction is challenged, it is to be proven not by the courts, but by the party attempting to assert jurisdiction, which will be me. Your Honor, the burden of proof lies with the asserter.
Okay, I'm now finding, it just wasn't listed as a motion, but I do see it's in the docket right here, something that you filed. It's entitled Pro Se
with a prohibition.
Right, got it. So I've got that. I will rule on that. I'm going to give the state a chance to respond, but you just filed, you filed it a couple weeks ago, and so I'll get input from the state on that, and then I do owe you a ruling on that. That does not prevent us from doing the arraignment.
It does, Your Honor, because the law states that anytime a court jurisdiction is challenged, it must be proved. It must be proven before the case can proceed, Your Honor.
Okay.
So I challenged the jurisdiction last month, March the 4th. So that means that you have to set a court date for me to prove that you lack subject matter jurisdiction. I mean, I have bring my evidence, the state bring their evidence, show jurisdiction, and I'm not a statutory entity, so therefore statutory law don't apply to me, Your Honor.
Is the writ of replevy, is that your challenge to jurisdiction? Or
that's to go with my writ of prohibition.
Okay. Let me see if I
got my prohibition. I filed 2 motions.
Okay, let me just take a look here.
I have a lot of questions that I need to be asked.
As long as you read slowly, we'll get through that. Okay, I think I've got your writ of prohibition also. And is that the challenge to jurisdiction?
Is that for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction? Yes.
Okay, I see that. It says for fraud. Yep, they're all there. All right, so you filed them. I'm making a list here of things that I need to work on, and then I'll need to let the state respond. The way it works, if you file a motion, the state gets a chance to respond. Once I have both sides, then I can rule on that. Okay.
I mean, but you're still trying to proceed with the case, Your Honor, when we haven't established. You're trying to get me to plead when this case is supposed to be at a standstill when I changed the jurisdiction March the 4th of last month. So that means you have to prove jurisdiction before you can make a plea on this, Your Honor.
I'm fine delaying the arraignment while we work through this. We don't have to do the arraignment today. I can hold on to the discovery and get you that another time. If you would prefer that I let the state respond and then I rule on it, we can handle it that way. Is that what you'd like?
I would like if we can just answer these questions that's here right in front of you today, Your Honor.
So then don't read the motion anymore and tell me what are your questions.
I won't read the motion. I'll read what I have wrote down, my issues I have.
Okay, but ask questions instead of telling me about these cases.
Your Honor, I am on, let the record reflect that this is the defendant, this birth certificate, which is the person slash persona, which is a legal fiction, also a statutory entity.
And I can't understand it.
Okay, I need you to slow down a little bit. So,
Let the
Mr.
record reflect, Your Honor, that this birth certificate is the defendant. I'm physically showing the birth certificate. Everyone in the courtroom, that this is the defendant, and I am the defense.
Okay.
Your Honor, I am only here in this courtroom by special appearance on the threat and duress to administer affairs of the Our Cap Trust, which is this birth certificate.
Okay.
As a sole beneficiary.
You told me you had questions. Tell me.
Yeah, I'm getting to it. I'm just introducing to the question, Your
I
Honor.
want you to go straight to the question now.
Your Honor, is this courtroom a court of records?
Okay, what's your next question?
Is this, you can answer it? Is this courtroom
I
a
want
court
to
of
know what
records?
your questions are.
I'm asking the question, Your Honor, is this courtroom a court of records?
So I thought you were going to share with me what the questions were. I didn't tell you if I was going to answer the questions. You said you had a bunch of questions.
So you're going to have me ask questions that you're not going to answer, Your Honor? That's not fair.
Well, don't ask the questions then. You don't have to ask the questions. You said you wanted to ask your questions, and I'm happy to hear them. If it's appropriate for me to answer them, I will.
So you don't think me asking is this court of records appropriate?
I didn't say it was appropriate or inappropriate. I just needed to know what your questions were. And if they're ones that I should answer right now, like what time is it? I can tell you, 3:51.
Yeah, and I'm asking something very simple, Your Honor. Is this courtroom a court of records?
All right, and what's your next question?
Your Honor, is your courtroom a court of records? I can't get
That
past
seems like
these
the first
questions. Need
question.
to be answered before, Your Honor. This question need to be answered for me to proceed, Your Honor.
Okay, tell me
I'm
what
trying to get an understanding. If you're not trying to help me get an understanding,
tell me what you mean by a court of records.
is this a court of records? It's simple.
I don't know what that means.
Is this courtroom a court of records?
I don't know what court of records means.
Do they record and proceed on everything that's happening in this courtroom? Do they record and document everything that's happening in this courtroom?
I don't know about everything, but as long as as long as you're speaking slowly and clearly, then things are being taken down. What's your next question?
Is this Fulton County courtroom a court of records? The same question you're not answering, Your Honor. You're trying to dodge the question.
No, I'm not. I want to make sure I understand the question.
Is this Fulton County courtroom a court of records?
At times it is.
And are you sure this courtroom is a court of records?
If court of records means we take down what is said in court, then yes, sometimes this is a court of records.
For the record, Your Honor, I go by Ricky DeMond Pierce, all lowercase letters, nothing more, nothing less. Again, I'm here by special appearance on the threat and duress to again administer affairs of the Our Cash Trust as the sole beneficiary and a shareholder of the trust, which again is this birth certificate. Okay, I'm also the executive of this estate, and I'm not the living person, not the person or persona, which is a statutory entity. I'm not the all caps legal official on my corporation. I'm the living.
We're only on 1.25, but for interest sake, I'm going to put it on normal. It's still a lot.
And I have proof signed by your government agreeing to the same.
So what's your next question?
Your Honor, before we could proceed with this matter, I have a few questions I need for you to answer. First, Your Honor, are you practicing color law behind the bench?
I'm not sure what you mean.
Are you practicing color law behind the bench? Because Title 18, U.S.C. Section 242 clearly states that you are committing a felony if you are doing so. Title 18 states, whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subject any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured by and protected by the constitutional laws of the United States shall be found under this title or in prison not more than 1 year or both. And if bodily injury results from acts committed in violation of this section, or if such acts include the use, attempted use, or threat of use of a dangerous weapon, explosive, or fire, shall be found under this title or in prison no more than 10 years or both. And if death results from the acts committed in violation of this section, and if such acts include kidnapping, attempted to kill, shall be found under this title or in prison for a term of years or for life or both, or may be sentenced to death. Now, my question, let the record reflect that no legal or lawful matter can proceed without jurisdiction, Your Honor. We both know this.
Right. So we're going in circles. We're back.
Let me finish. Your Honor, my question to you is Your Honor, for the record, is this matter a criminal matter or a civil matter?
What do you think?
I just want to answer.
You're standing there in handcuffs. You're wearing a jail outfit.
Can you please answer the question for me, please?
My answer, I'm answering with a question. What do you think? Lowercase
I don't know.
r,
I don't know,
lowercase
Your
p.
Honor. That's why I'm asking. I don't know.
think you
That's
do
what I'm
know.
asking.
What's your next question?
Is
Ask
this,
me a
Your
question.
Honor, Your Honor, for the record, is this matter a criminal matter or a civil matter?
Ask a question you don't know the answer to.
I don't know that. I'm telling you, how you gonna tell me what I know, Your Honor?
Well, if it were a civil matter, would you be having to use the restroom in front of everyone else?
Oh, no, that's why I'm asking you, Honor. I'm coming to you as fast as I know how, Your Honor, and humble as I know how. I don't know. That's why I'm asking the question.
Okay. What's your next question?
Your Honor, for the record, is this matter a criminal matter or a civil matter?
Okay, that would be your next question. That's one you already asked.
Why we can't pass this question, Your Honor, because I lack knowledge to understand what is going on. And I'm telling you this, and it's my authority to let the court know when I don't understand something.
A fair point. I want you to let me know when you don't understand. We already covered that when we had our Feretta hearing. We talked about what kind of case it is and the penalties you
That ain't what
face.
I said. Is this a criminal matter or a civil matter?
How much more time do you need? Because you got about 3 minutes before I'm going to bring someone out here that we can move the case along.
Your Honor, I just want you to answer my questions because I lack knowledge to understand what's going on. I'm just trying to keep caught up to date to understand what is going on.
Okay.
There's no harm in that, Your Honor.
What's your next question?
It's the same question. Before I can get to the next question, I have to answer this question.
Go to the next question. You just said you're not gonna
Your Honor, for the record, is this matter a criminal matter or a civil matter, Your Honor?
All right, we're done. I will bring you back once the state has responded to your motions, and I will likely be entering an order that lets you know my thoughts about jurisdiction. Once I've done that, you can choose to participate in an arraignment, but you do need to understand that in a criminal case, that's a clue.
So this is all a criminal matter. Why you couldn't answer the first time, Your Honor?
Why are you asking in the first
Because
time?
I'm trying to get, I just told you I'm trying to get an understanding.
So let me finish. So you understand that in a criminal case,
So this is a criminal matter, for the record.
such as yours, if you choose not to
Objection,
participate,
Your Honor.
if you choose not to
Is this a
participate,
criminal matter or a civil matter, Your
you
Honor?
need to stop interrupting, okay?
I'm trying to understand something. It's my right to, if I don't understand something, to bring it to your attention, Your Honor. That's the law.
It's not the law, it's how you're choosing to proceed. If you decide not to participate in arraignment, I'm authorized by law to enter a plea of not guilty. And that's what I'll do. So when I see you again, we're going to try again with
So
the
you're
arraignment.
going to violate the laws to when it states that a case cannot proceed without establishing jurisdiction first. So you're just going to ignore that.
Nope, I'm going to rule on your motion. And after I've done that, then I'll bring you back for arraignment. And you can choose to participate in it or not. I'm just letting you know in advance so you're not disappointed.
I'm not going to participate in it until you establish jurisdiction on me first. That's the first thing first. We're not going to skip the process. This due process of law for a reason, Your Honor.
It is, and that's why we're not
And in
doing it.
Hagen versus Levine, it states that anytime a jurisdiction is challenged, it's to be proven before the case can proceed. That is the law. That is not nothing that I made up, Your Honor.
Okay, you may be misapplying it, but I'm not disagreeing.
I'm not just I done read it 1,000 times, Your Honor.
Okay, well then you know it. So that's why we're not doing the arraignment today. I'll take care of establishing jurisdiction. And once I've done that, I'm comfortable that I've established jurisdiction, we'll bring you back for an arraignment. You can participate or not, but we'll have cleared that hurdle that you.
If you haven't, I'm not going to participate. If you can't establish jurisdiction over my case first, why would I participate?
You don't need to participate. I'll bring you out. You can say no, thank you. We take you back there. We bring the
No,
jury in.
I mean, Your Honor, I have issues, and it's
You do.
yeah,
You do.
yeah, and we both do, Your Honor.
And my responses, do I address them to, as Mr. Pierce has recognized to start the day as lowercase r, P, progressive name, because he signs all of his motions with uppercase R, uppercase P, uppercase.
No, I don't. I do uppercase or lowercase everything else. Dash. I don't have an art sentence. I have an autograph.
It's just different. I respect that. I just was curious. It's different than what he.
Let me show you.
I got it right here.
Right. No, I'm looking at it. It's capital R, capital
Lowercase.
E.
No.
Oh, yes. But that's all right.
Is that all caps?
No, it's not all caps, but you capitalize each
Yeah,
word.
This is all cap. Is this your handwriting?
What?
See, that's all caps.
Oh, that's awkward. All right.
Is that in all caps?
So how about this, Mr. Pierce? I'm going to agree that you have written it in different ways, and I'm really not going to get hung up on that.
I'm not all, you know, like I got the paperwork right here signed by the government saying I'm not a part of y'all, and it's on file with the office. It's filed in office. My paper right here shows that I'm not the all caps legal official signed by y'all government.
Good.
Signed by y'all government saying I'm not the all caps.
I will not
I'm
use
not
all
the
caps.
corporation.
I will not use all
Signed by
caps.
you guys government.
You guys. Okay.
Because I'm a national, not a citizen. Y'all are citizens. I'm not.
I remember you establishing that before. We don't need to cover that again.
It was a very much that I present it at every court because it's for the record. Now it's my job to put it on the record, Your Honor.
Okay. It's back on the record. We're incorporating in this hearing what you put on the record at the last hearing, and we'll do that every time. Anything else you want to cover? Because I'm happy to give you this discovery, but you can't have it.
I don't want to
So
proceed until I get my question answered, Your Honor.
All right. Why don't you do this? If you want to put them in writing, you could file them and I can get you those answers. But we're wasting not your time or mine, an important conversation, but there are a lot of other people here who are stuck while you ask questions like, is this a criminal matter or a civil matter? So
right, because I don't understand.
Okay.
And I just want to ask you where is the problem just answering the question, Your Honor? Because I let the knowledge know.
Okay. I feel your lack of knowledge, and I'll bring you back after I've responded to the motions you filed. That's the way we're going to interact here. If there's something you want an answer for or ruling on, you need to file it. And you know how to do it. You did it well. Okay? I'll keep your discovery warm and dry in my office.
I feel your lack of knowledge.
So would you just continue this court date or something?
Yeah, we can't do the arraignment today. You've helped me understand why. You want me to
because
establish.
You can't proceed with my case until you establish jurisdiction over my case, Your Honor.
That's right.
That's the law.
It is the law.
So what's the problem with me asking the question to better understand what's going on?
Well, I don't even have jurisdiction yet. Let me establish that. Then I'll be in a position to have a conversation with you.
And we're not talking about statutory jurisdiction. We're talking about the Constitution jurisdiction.
We're talking about whatever jurisdiction I find. Okay? I'll see you soon.
Bye, Judge.
That went differently than I expected. Really? I thought just by letting him vent that first time, he purged himself. Clearly not.
Your Honor, I have an announcement on Mr. Estrada's case.
Yes, let me turn to that calendar. This was just a fun little carryover from this morning. Mr. Estrada is right here. Yes, ma'am.
I discussed it with the state.
I love Judge McBurney. Sometimes he will make his thumbnail say Judge McWordy because people say he's too wordy. I love him. He's so funny. Hey, Fuzzy. That's Judge for I really want to laugh at you, but other people might start asking for exactly. Another judge that I love dealing with a sovereign citizen. Also, I can't stay super long. I need to get back to work soon. But Judge Babcock is so sweet. Hello? Why is it not? She's so sweet. I just want her to read bedtime stories and teach me law like I'm 5. Yes, her name's Babcock for all the dirty little minded people. I think this is the guy. I think.
Good morning. We are on the record in the matter of People versus Latavis, Trishad Thornton. This is case 25-0203-FY. May I have appearances for the record, please?
George, thank you, Andrew. George, in the behalf of the people.
Thank you. And Mr. Thornton, could you state your name for the record, please?
I am Shoulders in here by way of Executive Office for Latavius Trishad Thornton nonprofit organization.
Accept that as Mr. Thornton announcing his appearance before the court. We are here this morning for a pre-exam conference. Mr. Anid, it is my understanding that Mr. Thornton has declined representation. However, Mr. Thornton, at every appearance, I need to remind you that you have a constitutional right to be represented by an attorney, and that if you can't afford an attorney, the court will provide one for you. I am particularly proud of the superb public defenders we have in this court. However, you may also retain any attorney you wish. You will get to choose the attorney. You would have to pay them. You have a constitutional right to represent yourself, but I have to warn you that if you proceed representing yourself, you would be held to the same standard as all attorneys who have gone to law school, passed the bar, and been admitted to practice. So the court really can't give you any breaks or help you at all. Is it your wish to represent yourself, sir?
Mr. Thornton is aware of the courtroom decorum and the standards and procedures that must be upheld by a person in representation of a party. And as again, Shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used, and to uphold the proper standards. Mr. Thornton does not wish to get public counsel representation as I am a legal representation by special appearance through the executive office for Mr. Thornton and not the actual entity, Latavius Trishad Thornton. Once again, on the record, it has not been declined that Latavius Trishad Thornton is a nonprofit organization, which, yes, Your Honor, is a person, in fact. And I, the man speaking with a voice and a
So
sound
I'm going
mind.
to cut this off. I don't want to mute you, but we have to move forward. So we have an attorney standing by. That would be Mr. Foreman, who is a very, very good public defender who is available to you. At this point, Mr. Anid, this is the time and date set for a pre-exam conference. Have you had an opportunity to speak with Mr. Thornton about any plea offer?
No, Your Honor, and I don't think I'll have any meaningful conversations with him based on what I see. I believe that it's not clear whether what he's doing is intentional or whether this may be a competency issue. But I'm prepared to proceed. I just don't know if we should. I have a concern for his competency, to be honest with you. If of course we had the same issue this time.
No, Mr. Thornton, one person at a time. And right now, Mr. Anid is speaking.
I mean, I guess I would inquire with whether he knows what a preliminary exam is, and if he understands, if we forward, if he's gonna know what to do. I mean, I believe I have to look at the court rules. I've never dealt with this issue, but I think having standby counsel would be something that would be needed to advise him. I'll look into all that, but I just don't know if he's gonna know what a preliminary exam is. I believe this may just be a competency issue. I don't know, Your Honor.
Okay, so actually that's a good question. So Mr. Thornton, I'm going to ask you, what is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir.
you?
No, we're gonna focus our answers here. What is a preliminary exam?
Your Honor.
I'm going to give you
Your
one
Honor.
chance to answer. What is a preliminary exam?
A court proceeding. Mr.
Okay,
Thornton
and
will
what-
say that a preliminary
Okay,
examination
and what
court proceeding-
happens, that's a good answer. What happens at that court proceeding?
At a preliminary examination court proceeding, the parties have the opportunity to present evidence, cross-examine each other, and determine whether a case is, whether evidence is admissible to go into, to put continuing proceedings, whether the court has jurisdictions, a plethora of matters may be brought up in a preliminary examination to see if the court has a valid standing, to see if there's anything, to see what may be addressed that's necessary as far as the parties that are at hand, not only to go about things in a one specific fashion.
Well, that's pretty, that's a pretty good answer. However, at this point, given a review of
Your Honor,
history, the court is going to sua sponte, suggest that a competency exam be ordered. Mr. Anid,
I
any
agree.
response?
I agree.
Okay, thank you. Mr.
Yeah.
Thornton, any response?
Mr. Thornton does not believe that a competency exam sua sponte is necessary and objects that as a preliminary exam is something that we can proceed to and we can address the matters and the situations that are necessary at that time. And for the sake of due process and the judicial precedence of due process, that a criminal or a competency test may delay that, and it could hinder not only Mr. Thornton, but the things that Mr. Thornton does as far as the community and his career and his family and his life and rights and other people that may be affected by this matter, as well as the public. Because for the judicial precedence is that Mr. Thornton is innocent and not guilty.
So, Mr. Anid, are you going to prepare a proposed order or?
Your Honor, I think it's been a while since I've done. I believe if I'm not mistaken, it's the. I can if you want. Yes, I'll prepare an order.
All right, so at this time, Mr. Anid, comment on preliminary exam?
No, I just say we just make the preliminary examination to be determined date. If anything, reset it for another PCC or a review hearing for when we do come back with a competency opinion.
Okay, so Mr. Thornton, you have two rights at play here. One is the preliminary exam that we just discussed, and the second is the right to have that within 21 days. So the reason that you have a right to have that within 21 days is to prevent cases from dragging on endlessly. There are certain timelines that have to be met. However, the court can waive that 21 days if it finds good cause. And that would be, for instance, if one side had recently received discovery and was unable to proceed. Another good cause could be if someone was ill or hospitalized. There could be any number of good reasons. So I'm going to ask you, actually, Mr. Thornton, have you received any discovery in this matter?
I have not. Mr. Thornton has not received any instrument.
Okay, so, all right, two things then. First, I find good cause to waive the 21-day rule, and we will get a date. No, sir, just a minute, let me finish. You don't, no, listen, I don't want to mute you, but I have to get through this. So you have to have, you have a constitutional right to have knowledge about your case. And if you haven't received any discovery, we can't go forward until you receive it. So two things. First, I'm going to waive the 21-day rule. And just a minute, Mr. End. We're going to waive the 21-day rule, and we're going to set a date out in about a month. That'd be a placeholder date. As soon as we get that date, then we'll go to the discovery issue. So next up, we're going to adjourn this case to we're going to adjourn this case to I just lost that chat. To a probable cause conference at 8:30 a.m. on April 25th. And a preliminary exam date of 9 a.m. May 1st. Now, Mr. Anid, You wanted to be in a breakout room with Mr. Foreman. I'm guessing you want to discuss discovery. So
And you, Judge.
with me, or you want to discuss me?
All three of us really quickly. That's okay.
Okay.
I would like.
Do that? Okay. Just a moment, Mr. Thornton. We'll be back in just a moment. Okay. Thank you.
These will be right back in shortly.
All right, we are back on the record in the matter of People versus Latavis Rashad Thornton. This is case 25-0203-FY. And for a moment, at Mr. Anid's request, the court, Mr. Foreman and Mr. Anid discussed standby counsel. So standby counsel is something with certain mechanical concerns. So for standby counsel, the court can't just appoint standby counsel. This is what we discussed in the breakout room. The court, or perhaps its funding unit, the city of East Lansing, would have to enter into a contract with the public defender's office. And if both sides agreed to that and a certain financial rate, then an attorney from the public defender's office would sit next to Mr. Thornton and be available to advise him during all proceedings. Back in the day, when I was on the court appointed list, a judge could just appoint someone and do it. That doesn't exist anymore because of the MIDC. So we discussed the mechanics of that. The court is going to make a formal discovery request on behalf of Mr. Thornton. So Mr. Thornton, you should receive at the jail, or if you post bond at the address we have on record, all of the materials that a defense attorney would receive that the prosecutor has. At this point, Mr. Anid would like to speak with Mr. Thornton and perhaps see if a plea deal is possible. So Mr. Thornton, you never have to accept a plea deal, but it's worth listening for two reasons. First, there may be something there that you can reach an agreement on. You have a constitutional right to have these charges heard in a trial. Sometimes you can make a bargain, something that is worth giving up your right for a trial, for instance, a lesser charge, a lighter sentence, or both. The other side is you kind of want to know what the prosecutor's thinking about the case. So, as defense attorney, I always wanted to hear what the plea offer was. Even if my client was absolutely not going to take it, it gave me some insight into where the prosecutor was interested in going with the case. Again, you were never required to accept a plea bargain. At this point, because you are representing yourself, I'm going to allow you to converse with Mr. Anid, recognizing that you do not have discovery materials, so I do not expect this court to accept a plea bargain today. All right. We're going to put you both in a breakout room, and when you're done, the court will be ready. Thank you. Sound is back on. Okay, let's see. Wait for, there we go. All right, so we're going to wait until the sound is back on in the jail for Mr. Thornton, and then we'll resume. Rashad Thornton. This is case 25-0203-FY. Mr. Anid, prosecutor, and Mr. Thornton, representing himself, have met in the breakout room. So first, because the prosecutor has burden of proof, I'm going to ask Mr. Anid first, then Mr. Thornton, I'll ask you. So Mr. Anid, anything from the breakout room that you'd like to report?
Yes, I just want to make sure Mr. Thornton is there because I don't see him on here.
Oh, I see him.
Okay. Can you hear me? Okay. Yep. So we discussed. Yep. We discussed a little bit of as much as we could. I believe based on my discussions with him, I don't believe this is a competency issue. I believe this is more of the what Mr. Thornton kind of described earlier. So the plan, I think we both agreed on, is we're asking for another probable cause conference. I'm going to somehow figure out how to provide him discovery the complaint, the information, all the charging documents that we have. We're going to come back. In the meantime, I'm going to do my due diligence to speak with our office to see how we're going to go forward with this. Because I know it's my understanding he wants to represent himself. That is his right. I believe based on the questions that you asked earlier, he answered them pretty fairly, Your Honor. I just want to make sure we got all ducks in order. I discussed a misdemeanor offer potentially with them, but also discussed that I encourage him to get a public defender. All these things I think we're going to discuss at the next probable cause conference. I think these are all appropriate matters, so I can get my ducks in order. He can have discovery to know what he's looking at. And I believe at the next hearing, we will have a good understanding of what we're doing going forward.
Mr. Thornton, is that an accurate report?
It's pretty accurate, Your Honor. Just a few more points that we had discussed in that breakout room was also that it was in the discovery we would like to get subject matter in the appointment of the authorities that has been filed onto the record for these proceedings and how we came about to be into the court's jurisdiction for this matter in such fashion. And I think that's kind of what
that's a word salad. It's not making any soup. Can you make sense at all? Can you rephrase that for me, Mr. Thornton?
So just pretty much all in the discovery, we didn't want any documents that have been filed onto the case to be missing, and that's what I mean by not limited to the documents titles that he named. It include an inclusion of all documents filed with all titles under them.
Okay.
I'll
Yes,
chime in
Mr.
here.
Ned.
And I think kind of what he may be talking about is, and I could be wrong, is the charging documents, what gives us the authority to proceed forward and how we're proceeding forward. And I explained you should wait until you discover, because I believe that's going to be the complaint, the information, and the other charging documents to see where we're at. I could be wrong, but once he receives those, we'll come back. We'll have all the ducks in order. I think that's a good resolution we both agreed on. And in the meantime, I'll do my due diligence to speak with our officer how we're going to go forward. I told Mr. Thorne, I'm the prosecutor. He understands what the prosecutor is. I'm not on his side, but I did advise I'm here to help get the situation resolved as fast as possible. And I think we both agree that if you find good cause to adjourn this for one more probable cause conference, I believe everything will be situated. The only thing I have to ask is, how do I provide discovery to Mr. Thornton?
I would guess that you could mail it to him, or I think
I'll figure it out. I'll ask my office.
Communication through the jail.
Okay.
At his address through the jail, and it may have to be paper communication.
Okay. I'll do my due diligence today when I get to the office today, Your Honor.
Okay. And I don't have discovery demand in front of me, but that would include, of course, any exculpatory materials granted under Brady. That would include make a request for any body-worn camera, any evidence you plan to introduce, any car video, any report that you have in your office other than what's protected under attorney-client privilege with the prosecutor or any counsel. Mr. Thornton, anything further this morning?
Not at this time, Your Honor.
Just new dates, Your Honor. New dates, new probable cause.
Okay, so we had the dates, and that is 8:30 a.m., April 25th, for a probable cause conference, and 9 a.m., May 1st, for a preliminary exam.
Okay, so I'm going to need to stop pretty much there because it's lunch. Love how half my head is cut off because it's lunch and I need to go back to work. So what's interesting is when she addressed him as Mr. Thornton, he responded. Kind of sounds like he might be Mr. Thornton and not the trusted beneficiary, living entity, man, corporation, organization, jurisdictional, mythical, regional, diagonal of the trust of Thornton. Thereby special divine appearance. Exactly. Okay, so yeah, I said at the beginning, but some people might have missed it. I decided to just come back in for a lunchtime live today because Kathy, who is Court Vibes, is working on Wednesdays, and I am not quite at the point where I can do long streams. I've got a lot of work going on at the moment and that sort of thing. So I thought I would hop in for this one while she's off. I don't have anywhere to redirect you to because the next streams are coming up in the afternoon, but American Courts Bill from American Courts is doing Fleischer at 4 my time, so 3 hours from now-ish. Can we see the cat cam in the near future? Yes. I didn't do anything today because Vaughn is in a meeting and I didn't want to accidentally pick up work stuff. Because this isn't my proper setup. So it's literally just my laptop mic. And I didn't want to go walking around or anything. Oh, Bill is court vibes. Yes, of course. And Kathy is American courts. Yeah. 9 months. The first baby macaroni is born. All right. I will see you guys soon. I'll see you in court vibes chat tomorrow, most likely. I generally am there every day. I just don't say much because if I start getting stuck in the chat, then I just don't get anything done. So, all right. Have a good one. I don't think I have like an outro or anything anymore. Did I have an outro ever? I can't even remember. I don't remember. I'll just play verdict music for a few seconds and say goodbye. Let's see, I can't move it along. Okay, bye.